Go? Okay. So, hello everybody. It's great to have you in our webinar together with you. My name is Rolf Guenter. I'm the co-head of the Zurich chapter of Swiss Legaltech Association. And I will very welcome you in the name of Swiss Legaltech Association and our corporate member, you to this webinar. So let's start with a short introduction of Swiss Legaltech Association. And then I will hand over to our main part. This is my colleagues of you, and I will start with a short introduction. Let me see if I can do that. Share in full. So I hope that's fine.
We cannot see yet, but maybe it's just a matter of time.
No, you cannot see something.
So did you say?
So then let's do it without the two slides. So not to lose time. Yeah.
There is a action button
share my screen.
You can try to use with share.
No,
if the other way is not working, you can try this one.
I see it. Share media. No,
not work.
Doesn't work.
Okay.
No, yeah, it's okay. No, it doesn't work. So do you see now the slide?
It happened for a minute, but I cannot see that again. I don't know. Maybe you can.
Okay. So let's do it without the slides.
Okay. Otherwise, you can send me over the link.
These are just two slides. So no, let's stop that now, because I afterwards to you, because you have a lot to show us and to tell us. So just to introduce Swiss Legaltech Association. So at the end, we can say in a nutshell that Swiss Legaltech Association is the think tank in Switzerland with regard to legal tech initiatives. So we are a group and a community of about more than 200, 250 individual members in Switzerland, and of about 50 corporate members. And we are growing very fast, and it's a very intensive exchange of knowledge and ideas and possibilities. That is the interesting thing for everyone to participate in the Swiss Legaltech Association. So we are on the forefront, we can say, of these initiatives which focus on legal tech possibilities and instruments in the Swiss market. It's not just the Swiss market. We have as well very good connections to the European colleagues and associations. And what is very important as well, we will do a first bigger event this year together, a joint event with the Swiss Bar Association. So that's for us a very important step as well. We think that we have three levels of maturity with regard to legal tech. The first one is really just office automation. And we think we are in this phase, on this level, and a lot of companies are struggling with this topic as well. And the law firms are investing time and money now to really have the ability to automate processes in the office, to use tools very efficiently. And that's just from our side, our point of view, the first step. The second level is when we go and try to integrate our customers in legal service processes. So that's the next step. And the third level is really where AI and artificial intelligence comes in, where we really can use a lot of data, where we can see how these data flow into the processes and make much more, or give us the possibility to start and to work in a much more efficient and effective way. So what we will have today, and that's the point where I can hand over to our guests and to our colleagues and corporate member, Euro, where really automation is on the side of the clients, on the side of the law. So we are now talking about the second and the third level, I think. And I'm really happy to hand over now to you to see what your solutions can show us and how we can make benefits out of your solutions in the future in the legal industry. So thank you. I will hand over to Raffaele and have fun.
Thank you very much, Rolf, for this introduction. Hello, everyone. Thank you again for being here with us today. So my presentation is about the smart legal contracts. And in order to talk about the smart legal contracts, we need to start from smart contracts. What you are seeing here in this on this slide is a very famous statement about smart contracts, according to which smart contracts are neither smart nor contracts. Actually, according to someone, smart contracts are not smart because they do not learn, they do not improve, and they are not contracts because smart contracts are piece of software, are code. In my personal view, this statement is really catchy, but it's not always true. And I will try to explain myself during this presentation. And first of all, let's see what a smart contract is. Smart contract is not something that is born with blockchain, as actually many think, but smart contracts were first theorized in 1994 by Nick Szabo, who is a computer scientist with a background in law. And in 1994, he said that a smart contract is a computerized transaction protocol that executes the terms of a contract. So the inventor of smart contract thought that smart contract is a tool to automate the execution, the enforcement, the performance of the terms of a contract. So the smart contract is a software born with this specific objective in mind, with this specific function, automation of contract performance. Then in 1995, Nick Szabo gave us another definition, according to which smart contract is a set of promises. So he started to move from a pure software to something that is more contractual, from computer science to law to contract. And he specifically mentioned the fact that smart contracts are smarter than their paper-based ancestors, in the sense that they are more efficient, more cost-effective, easier to be used. So this is the meaning of smart. Smart not in the sense that something that is intelligent, like artificial intelligence. That is something that Nick Szabo expressly excluded in this definition. Nick Szabo said that no use of artificial intelligence is implied, because smart contracts are software that do not learn, do not improve themselves, but they actually help to make it easier to automate the execution of a contract, the enforcement, the performance under a traditional contract. Finally, in 1996, Nick Szabo said that a smart contract is a set of promises specified in digital form. This is the last definition available from Nick Szabo. Now we have to jump 18 years in the future, up until Ethereum was born. That Ethereum is the first blockchain platform created to automate the enforcement of contracts. It's the first blockchain born for smart contracts. Ethereum uses the definition smart contract from Nick Szabo to explain, to address a permanent script computer code on blockchain. We should actually use the sentence, the expression, decentralized smart contracts. But currently, when we say smart contracts, we are implicitly saying that is a software on a blockchain. So today, smart contract is a permanent script on a blockchain. Now we can understand better some of the characteristics of a smart contract. A smart contract is an event-driven software. It's a software that requires an event, an information to be executed. It's a software that requires an input to provide an output. And the smart contract is written, of course, in computational logic, meaning that it is written using a sentence expressed in if event, then consequence, else alternative consequence. So obligations are expressed in computational logic and then translated in programming language. And for example, Ethereum and VeChain, which is the blockchain where Jure has developed his own platform, adopt a programming language called Solidity. The aim of a smart contract is the self-execution of performances. In this slide, on the left side of this slide, you see a smart contract. This is the so-called tooth fairy contract because it's a smart contract regulating the transfer of cryptocurrency, Ether, from the smart contract to the wallet of a child who has lost his tooth, his or her tooth. Although this was, a joke smart contract, actually it allows us from a legal standpoint to understand a couple of elements that are very important. First of all, this smart contract requires an event, the status of the tooth, that is not something that is built within the blockchain. It's something that is in the real world, something that is outside a blockchain. It's something called off-chain. And we need something or someone that takes this information off-chain and sends this information on-chain to the smart contract. This source of information is called oracle. In the case of this smart contract, the oracle is the mother. The mother is the only person that can give this smart contract the information concerning the status of the tooth. If we think of the role of the oracle, we understand that it is a very important role, because if the oracle is providing incorrect information or false information, the smart contract may be executed, although the event actually did not occur. So the parties of a contract need to trust the oracle. And this bring along with it several legal implications. Maybe we need to sign a contract with the oracle. We need to understand among the parties who is going to take the risks of an error from an oracle. And another important point that we can take from this smart contract is, what if the smart contract has no cryptocurrency in it? who is going to give the money to the child who has lost his tooth? This smart contract doesn't regulate this kind of scenario. So this is when a good lawyer enters into action. A good lawyer approaching a smart contract should think about any kind of scenarios that may actually occur, because once a smart contract is deployed on a blockchain, no one can change that smart contract. It is necessary to create a new smart contract if we have missed something. So a good lawyer in this case has to think about all possible scenarios and has to liaise with the developers in order to ensure that any kind of possible events, possible scenarios are regulated within the smart contract. So we have discussed briefly the oracles function that is very important. It is opportune to point out that oracles may be almost anything or anyone that can provide an information to a smart contract. So it might be a reliable third party, an institutional third party like a bank or an index or stock exchange. It might be the wisdom of the crowd, or it might be sensors like GPS sensors. Let's take let's use as an example the delivery of a container to a specific port. Maybe we can identify a GPS sensor as our oracle, providing the information to the smart contract that the container has actually arrived to the port. Or we can rely on the port authority. It's up to the parties to decide which oracle to rely upon. Many suggests actually to identify 3 different oracles and establish within the smart contract that the event is considered occurred when 2 out of 3 oracles provide the same information. Now that we have discussed all this information, let's see how traditional smart contract and smart contract can work together. In my personal opinion, there are 2 ways. The smart contract may be simply a tool to automate a clause that is regulated within the traditional contract. So the smart contract is not legally binding. The traditional contract is legally binding, and the smart contract simply helps to manage the actual performance of the obligation. Or the smart contract is a substitute of the traditional contract. Both these events, according to certain doctrine, it can be considered a smart legal contract because there is some kind of legal implications. But in any way, we need to be sure what's the boundaries between smart contract as a tool to perform under a contract, or a smart contract as a substitute to a traditional contract. Because only in the second case, the contract law would apply, provided that the smart legal contract complies with all the requirements under contract law, like offer, acceptance, meeting of the minds, a description of the performance, consideration. In this case, we would have a document that would be formed by traditional language and computer code all together in the very same document, in the very same text, with binding legal effect, where we can apply contract law. Although I totally see the difficulties from a practical point of view, I want to be very clear on this. From a pure theoretic standpoint, we may say that if a smart legal contract complies with the requirement under contract law can be applied. The problem then is not from a theoretical point of view, but it's from a practical point of view. How we actually apply contract law to something that cannot be amended by the parties, because from a technological point of view, that contract is deployed also as a computer software on a technology blockchain that the parties cannot amend. The parties have to create a totally new smart contract, and then they can use that new smart contract amended according to their new requirements. So there are, of course, many open points because this is something very new. There are no actual legislation on this, or better, there are laws on smart contracts, but there is no case studies and case law concerning actual application of such laws to an effective case. So if you have any questions, I will be more than happy to provide an answer. Thank you very much.
Thank you very much, Raffaele, for your speech. Actually, so you can go straight to it and see if you can answer.
Sure. A smart contract platform as a service or software as a service? Okay, let's start with the question from Megan Nairobi. Are smart contracts platform as a service or software as a service? Actually, smart contracts are software, are neither SaaS nor PaaS. The service providing the use of smart contract may be a software as a service or a platform as a service, but it depends on the actual platform, actual service. But the smart contract is a software. It's not a software as a service, and it's not a platform as a service. I hope this provided the answer. Then we have this other question from Tanvir Munim. Hello, Tanvir. Nice to see you again here. How the roles of traditional lawyers will fit into the concept of smart contract when it is self-executing in particular? Very good question. The role of lawyers, as I was briefly mentioning before, is at the conceptual stage when we have to develop the smart contract, because the smart contract is a software, but it is used to automate a contract, obligations of a contract, or to substitute a contract. This means that a lawyer is required to understand the legal implications of those obligations, of those contracts that we want to automate through a smart contract, and to be sure that all clauses, if can be expressed in computational logic, are translated in programming language in a proper way. This brings me to another point that I always try to highlight, that lawyers need to get accustomed to IT, need to understand how a computer works, how a computer developer thinks. This does not mean that lawyers need to become developers. This is not the case. It's not important, but it's important that we start to talk with computer scientists, with computer developers, with software developers, because I am sure that in the future, but in the very next future, we will be more and more working along with software developers. Federico, if I have more time, I may try to get another question.
Yes.
Maybe one from...
You still have 2 minutes to go, so there's still time.
Okay, just one. Okay. Lorenzo Piatti. smart contract can be deployed only on blockchain or also on a command of software deployed somewhere else. Centralized server can be considered smart contract. Okay, this is another good question. Smart contract is theorized in the 90s, where computer software for automate the performance of obligation. Then, with the advent of Ethereum, the smart contract, the concept of smart contract has been strictly linked to blockchain and decentralized ledger technologies. So if I have to give a reply concerning the current historical moment, and also in light of laws such as the one in Malta and the one in certain states of the United States, I have to say that currently smart contract is only when that specific software is built on a decentralized ledger technology. So today, a smart contract is only the computer software to automate obligation deployed on a decentralized ledger technology platform. Okay, I think that my time is up, and I would give the floor to Federico again. Thank you very much.
Thank you very much, Raffaele, and thank you everyone from the audience that you are so reactive and you are asking so many interesting questions. One thing that we didn't mention before is that we obviously don't have time to answer to everyone, but as we have seen also in the last webinars, every question that has been posted up so far are all very interesting questions. So we are creating also Medium articles that we will be then sharing on our official community on Telegram to answer all the good questions that are coming from this webinar. So keep an eye on that space for sure. And now, without further ado, let me please introduce you Luigi Cantisani, who is our legal engineer, Jure. He's an expert on dispute resolution. He will be talking about dispute resolution on blockchain. Thank you very much. Hello, Luigi. And
good morning, everyone. It's a pleasure to be here. I hope that you can hear me well, and I apologize in advance in the event that my Wi-Fi connection provokes issues. So let's get started. I hope that you can see my presentation. Maybe there's something not working here. Let me take it. Okay, here we go. Okay, so basically, as Federico said, I'm here today to talk with you about online dispute resolution. Okay, I assume that most of you in Switzerland are kind of familiar with online dispute resolution, or at least with the notion of alternative dispute resolution. The idea of having online dispute resolution is basically evolving the access to justice, but also the way disputes are managed. Okay. The idea is that alternative dispute resolution, current alternative dispute resolution mechanism can serve certain needs, but they do not cover all existing needs, especially in an era, during such an age where transactions happen quickly, business evolves quickly, you know, and you need reliable tool to cover your needs. And I also believe that the COVID crisis that we are experiencing is kind of shedding new light on the way justice is administered. But let's try to understand the evolution that brings to ODR, the used abbreviation for online dispute resolution, and especially what lead us to blockchain-based ODR. Okay. Alternative dispute resolution mechanism from a certain point of view existed since trade existed, because different trade needs needed different mechanism for resolving disputes. And you also need to keep in mind that the modern notion of sovereignty and state-based jurisdiction is something, you know, that happened during the last centuries. It's not been there. So since ancient times, and especially during the medieval age, the natural way for settling disputes coming from trade was applying merchant law, and the way to apply these rules were obviously tribunals not administered by states. And nowadays we are familiar with mediation, conciliation, also hybrid procedures such as mediation and arbitration. Now, regardless of if we want to consider arbitration part of the ADR group or something different, because there is this distinction between US and the European continent. But apart from that, the idea is that ADR is a sort of group that includes different ways for resolving disputes other than domestic litigation, you know? So the idea is that nowadays ADR are experiencing a sort of new, boom, a new growth. Why? Because on the domestic level, there is a need for reducing litigations. Domestic courts are overcrowded, proceedings are long, expensive, and most of the times domestic judges are not familiar with certain kind of business. And on the international level, we have a framework for managing contractual relationship due to international, conventions, but also to International Chamber for Arbitrations or other international ADR bodies. So in light of this, ADR is basically going through a new age, okay, of a new stage of evolution, let's say. And in the same breath, the evolution of internet, the rise of e-commerce platforms, and other way for establishing quickly contractual transactions, contractual relationships, basically brought to light the notion of online dispute resolutions. I believe that most of us have dealt somehow with eBay or PayPal or platform like that. Well, those have been some of the first successful example of ODR, okay? But now we hear about ODR in many regards, and so there is also a bit of confusion on what ODR currently means. I'll try to provide a sort of classification for ODR mechanisms, okay? This is the way I usually explain ODR mechanisms. My view does not necessarily have to reflect with your view, but what is important right now is that we understand the way we can implement online-based features in dispute resolution mechanisms, okay? So on the one hand, we have just online features. In my view, these are not proper ODR. They are just a way for, moving online to part of existing procedures in order to streamline that precise phase of that very procedure. So we can have, for instance, online application, online file cases, virtual hearings, okay? So you just take a piece and you move it online. On the other hand, you have electronic ADR or EADR, if you prefer. This is something different. The idea here is to imitate a non-online procedure and move it online, like moving it completely. So having e-arbitration, e-mediation, and so on and so forth. Obviously, most of the experiments made on ODR, can somehow inspire domestic cards. And so you can have kind of online cards. I don't believe that we are really there at this stage, but you can see that some phases of traditional civil proceedings, I mean domestic proceedings, can be managed online, like opening a file application, for instance, or submitting some kind of request. You know, that's the idea beyond the notion of online courts. Maybe in the future we will have fully online courts. They are not there nowadays, but that's the idea, bringing the experiments made within the ODR environment and bring that knowledge into domestic cards. And then we move to the most interesting part, the so-called automated ODR. The idea here is way more disruptive. It's not just about imitating something that exists, okay, in a non-online form, but the idea here is to implement somehow automation, okay? And there are blockchain-based ODR, which are something consistent with the idea of automation. Raffaele perfectly explained the notion of smart contracts. Well, smart contracts are a tool for providing automation, okay? So from now on, I want to focus on ODR, okay? And specifically on automated ODR. So let's move on. These are some interesting and successful examples of ODR that somehow have prepared us for the advent of blockchain-based ODR, okay? On the one hand, you have mechanisms such Cyber Settle and Smart Settle that basically were automated ODR. They still are automated ODR, and they rely on algorithms to provide decisions. In which way? Cyber Settle is based on the use of the so-called double-blind bidding mechanism. It is a mechanism according to which parties, the parties of an insurance dispute, so this platform was meant for insurance claims, they submit their proposals for resolving the disputes, and then an algorithm tries to strike the balance between this proposal. It basically suggests the solution that stays in the middle, okay? The visual blind binding mechanism used by Smart Settle is based on the same idea, more or less, but it's not about, in this case, the party are not aware of what the other party is willing to accept. But the idea of using algorithms for providing the outcome of the dispute is still there, okay? So keep this into mind, automation as a way for resolving dispute. And in this case, automation is specifically applied to the decision-making process. On the other hand, we have had platforms such as iCartHouse, which are not really based on automation, but they basically have been the first example of online platform, in that case a website, where anybody could file a case and where the dispute was decided by a jury made of site visitors. So you see, this was a sort of community-based mechanism for resolving disputes, because visitors, so actual users of the platform, are both parties to the disputes or can be the decision makers. Okay, are you there? That's the idea, having a platform that can bring people together for submitting disputes or decide disputes. Now let's go a step forward. There have been unsuccessful experiments for bringing all, let's say, this conquest to existing procedures. So the virtual magistrate was a pilot project launched in 1996, by certain institutions that collaborated for this project, including the American Arbitration Association. And the idea was to provide a fully online arbitration procedure, so bringing arbitration entirely online, okay, for certain kind of disputes. But the experiment was not that successful, and as far as I know, it was stopped, okay. Also, in Michigan in 2011, a law basically tried to create a cyber court for commercial disputes. So in this case, we are talking about a domestic court, but something fully online, okay? Now, all these, let's say, milestones give us an idea of what brought blockchain-based ODR to light, okay? So the idea is that internet is one of the most accessible way for interacting with people. And actually, there are more humans that are covered by internet than humans covered by justice and law protection. This is what an OECD report suggests, okay? So if that's the case, probably we need to pursue even better online-based mechanism for resolving disputes. And blockchain grants us an opportunity. The first opportunity is that blockchain, is way more secure. It provides immutability, stuff like that. So it seems the right tool for, let's say, tracking things that happen during a procedure. So having something like, for instance, the deposit of evidentiary documents, okay? It seems the right way for registering this deposit, making it easily traceable, So it's a good register and it's distributed, and that helps. Additionally, as Raffaele said, nowadays, smart contracts, thanks to blockchain, are becoming way more, let's say, used, okay? And so you can use smart contracts within this ODR mechanism. How? Here is the difference between mechanisms such CyberSettle that I mentioned before, In that case, the idea of having automation was applied to the decision-making process. On blockchain-based ODR, such as the mechanisms that Jure is developing, automation can be used to, and so smart contracts can be used to regulate the, let's say, relationships between the decision makers and the platform, so to govern the phase of the procedures. And also they can be used to support the execution of the contract. Well, the execution of the decision, actually. So let's say that you have a platform, and the parties to the dispute deposit the disputed sum by using an escrow smart contract. Then you have the disputed sum locked and stored, okay? And depending on the outcome of the dispute, the sum can be automatically assigned to the winning party, okay? And that's something good because it removes the need for asking for execution before domestic courts if the final result is already being put into practice. So as you can see, blockchain-based ODR are way different because they apply automation not to the decision-making process, but to the way dispute is managed. And as far as you are dealing with disputed sums, automation can be applied also to the execution of the decision. Just to sum it up, Jure's vision about blockchain-based ODR that we like calling smart ODR are that you can rely on humans for deciding disputes. So you're not really relying on algorithms. Algorithms are applied for governing the procedures and, where possible, to govern the execution. The idea is that you can bring more security and traceability. The idea is that you can implement tokenomics logic model to make people more engaged into this ecosystem, and also to reward the decision makers. And this tokenomics model can be constructed, and that's what we are doing, and also our competitors. It can be built on game theory. Game theory as a way for providing economic incentives and encouraging people to assess things in a fair way. And this also brings us to idea of having the so-called DApp model, which will be later explained by our CEO. So this is what I like to say to conclude. Law should be accessible to everyone at any time. This is not something for me. It's a quote from Franz Kafka. And we truly believe that blockchain provides us a good opportunity for making it not true, but say more true in some ways.
Thank you very much, Luigi, for your presentation. We have two very interesting questions, which, if you like, we would address as soon as possible. And you can start live answer by answering each of them, so everyone is aware of which question you are giving the answer to.
Okay. Do you have any question to suggest, or can I just pick one?
No, because there are two questions for you specifically, or now three. So you can start from the very first one that has 3 upvotes, then 2 upvotes, and then 0 upvotes. So you can follow this order. So we have 5 minutes from now for that.
Well, I will start with this that has 3 upvotes. So this one. Can you? Okay. So this one from Megan. How effective has the double blind bidding process been in light of algorithm discrimination? Well, this is the point. I can truly see discrimination here, because this decision-making process was really simple. The idea is that, party A proposes, let's say, 3, party B proposes 10, and the algorithm suggest something in the middle that could be, hopefully, accepted by both of the parties. That's the basic idea. I'm oversimplifying for sure, but I cannot really see discrimination there. So I guess I hope that this answers your question. But if you want to get back on this point, just text us. So I would move on with another one. Let's say link tutorial. Okay, let's split this one. How are collusions stopped? For instance, actors that handle dispute decide to provide bias-based resolution. Okay. Here we need to make a distinction. This answer truly depends on what kind of dispute or on what kind of dispute resolution mechanism you're building. So if you are creating something that is more community based, okay, so something like our open layer, let's say, the idea is that voters have to use their tokens, okay, and there are incentive mechanisms based on game theory that should, let's say, force the decision makers to provide a fair outcome, okay, because otherwise they will lose their tokens, okay. And I don't want to go spend too much time on game theory because it's very complex and it would require probably other 15 minutes to be explained. But the idea is that if I don't want to lose my tokens, because there will be a sort of, I know that there will be a sort of prevailing opinion, I should vote for what sounds the fair resolution proposal, okay? Because otherwise, crowd wisdom of the crowd based mechanism will lead other voters to pick the other proposal. That proposal will win, and I will lose my tokens. So I'm kind of, guided by these economics logics. If we have something different, something still based on blockchain and that uses smart contracts for automating the procedure, so a proper online arbitration, well, if you're an arbitrator, you will not be reliable, okay? Because on that, your credibility depends on that, okay? Your possibility of being involved by online arbitral chambers depends on that. So you want to be fair. It's the same logic according to which arbitrators try to do their best to be, involved in the arbitration community. So that should be your incentive. Let's see if there's something. Do I have time for another question, Fede?
If you want to answer briefly to the last questions, I think we can.
Okay. So, okay, let's go with this one by Federica Giordano. If I understand correctly, ODR will offer parties a possible compromise to resolve disputes. It will therefore be closer to mediation rather than arbitration litigation. What about the latter? Okay, so this is a very interesting question. Depending on what you're doing, you can cover certain needs. Within JUR, we believe that one size does not fit all. This means that you need to develop more than one mechanism if you want to cover more needs. So on the one hand, as you said, something like our open layer, I strongly recommend you to read our white paper if you want to know more about that. Yes, it's something that is meant to replace mediation somehow, okay? I'm oversimplifying. It's not mediation in the proper sense, but kind of, it's something based on submitting proposals. You have people that vote those proposals and so on and so forth. But on the other hand, you can also construct a proper online arbitration. And that's what we are doing within JUR with our card layer. So ODR can be used, as I said, the experiments that are made within the ODR environment can be used to create more than one procedure. And so they can also be used to bring existing procedures, such as arbitration, and move it completely online on blockchain by using smart contracts. That's the idea. I guess.
Yeah. Sure. So, okay, so we can definitely move to our last speech of today by Luca, our CTO. Thank you very much, Luigi, for your presentation. Always very interesting, and it arose a lot of questions that, again, we will be able to answer also not live, but in our main channels. So I invite you all to follow us on Twitter for sure, but also to join in our official channel in Telegram. So I leave the stage to you, Luca.
Thank you, Fede. Here we go. So I'm Luca, CTO of JUR. Let me see. I also think I can't currently share the screen. Let me check 1 second. Yeah, here we go. Just 1 second. Okay, you should be able to see my screen, Fede. Okay, great. So thanks, Rafael and Luigi, to give me the context, because both of them are lawyers, so they have talked more and mostly focused on the legal side of what we do, the legal side of blockchain, so smart contracts on one end, and alternative dispute resolution and blockchain on the other end. My talk instead will be mostly focused on the business side, which it's important to take in consideration when thinking about blockchain solutions, because especially for those of you that are lawyers, law firms, it's important that you are able to when you talk with your clients, to really understand the actual applications in the legal industry of this technology. Before doing that, I'll start with some definitions. So when we talk about blockchain-based platforms, like Joule, for example, we generally talk about a DApp, so a decentralized application, which, as you easily guess, it's different from a centralized application. A centralized application is the ones that we're using every day. I think of Amazon, YouTube, Facebook, Twitter, and so on and so forth. What makes a centralized application centralized is the fact that the data, so your tweets, the videos that you watch, the things that you buy on Amazon, that process, the history of the orders, and so on and so forth, all this data is stored on servers that are managed and controlled by Amazon or YouTube, or the specific entity that provides the service. So what this opens up, it opens up the opportunity for whoever is on the other end to control this value, and being able, for example, to charge other people, other clients, other customers for that value that maybe you have created. For example, if you open a YouTube channel, you are the one that is actually creating the value, right? Like, you're uploading your content, your explanation. Maybe you are a great lawyer, you're explaining, how to draft a wonderful contract, and that value gets stored on that platform, and YouTube as a way of giving this value to other users, and it's not really proportionate to what you get and what YouTube gets out of this valuable content that you have created. On the other side, we have a decentralized application instead, which allows the data, which stores the data on a distributed ledger. So it's not this data, it's not directly under the control of the authority or the platform or the service that you're using, but you can potentially directly have access to this data. This is very important, because it means that at any point in time that you want to transfer, say, your agreements or your smart contracts or whatever, you are free to do so. You do not rely on a specific platform, a specific service. At any point in time, you can create your own platform, maybe with your with the development team, your whatever. Like, you can recreate a platform that renders the data that you have created. That's a very important distinction. And whenever you talk about blockchain, you will see that applications tend to be decentralized. Of course, I've talked, about the technical differentiation, which is mostly on the data side, how the data is stored and managed. I briefly mentioned the business point of view and the philosophical point of view, because you are the one actually creating and generating the value, but someone else generally nowadays takes the major cut of it. So YouTube is a billion-dollar company, and instead your channel, might not generate revenue which are proportionate to the value that you brought on the platform. What the decentralization brings into application and platform is actually a way in which actors can interact in a peer-to-peer way. When we say peer-to-peer way, it means that I'm in direct connection with you, and in a direct trustless connection with you, which means that I really don't need to trust, for example, yes, YouTube again, to ensure that the data that the video that I'm seeing in your from your channel is actually yours, right? For example, you could upload a video in which you complain about some politician, for example, and I don't really have a way to be sure that the video that seems belonging to you was actually uploaded by you. But with the decentralized application, this is actually possible. And this enables, you know, really to take peer-to-peer transaction, being it economic transaction or any kind of valuable transaction, really possible. So this is important because it removes a lot of friction that we have nowadays when we interact with each other through other platforms, through other entities, through what we could call middlemen, right? So this is a very strong point of decentralization. It's whenever you can disintermediate the process and you can connect directly to the source, right? To the source of information, for example. Here is an example of a platform that we really like. We've been following Augur since its beginning, and as you can see, it doesn't really look like, you know, a streamlined, perfect web 3.0 platform. And this happens because the technology is in its infancy. If you go back in history and you will see how Amazon or Google, you know, were 20 years ago, you could definitely relate this to that. Like today, blockchain applications like dApps or any application that uses blockchain generally has a user experience friction. So you will see more and more of these type of applications rather than, you know, streamlined and, you know, the easy to use platform that we use normally every day. So it will take time for technology to evolve, and for, you know, it will take major use cases, major companies as well to bet on this technology and to be able to bring this complexity down and make it more user friendly and more ready for the end consumer. Now, the question that comes and arises, I mean, naturally, is, okay, I understood there are benefits for this decentralization, but it's like a word which is overhyped, which is trendy. So does really decentralization and blockchain mean that, you know, we need to move everything that we do today towards this type of approach, in which we try to remove the, you know, we reduce the impact of middlemen and so on and so forth? Not really. It depends from the use cases. I brought in, for example, Airbnb. Airbnb is a case in which decentralization seems like a good fit because, you know, you have hosts on the one end and guests on the other end, and right now Airbnb is a platform that sits in the middle and takes a huge commission for the service that it provides. But it's also true that Airbnb helps in the process of, you know, resolving disputes, for example, if they do happen, right? So if we disintermediate this process and we directly connect hosts with guests, and we could do potentially that through smart contracts and a dApp, we could do that. We should take in consideration the fact that if a problem arises, then what happens? And that's where, you know, solutions like the ones that we're developing at Azure are really handy, because they can help a decentralized application to become, you know, even safer to use and less scary in a way, right? Because right now, what we do when you use this kind of services like Airbnb, PayPal, whatever, eBay, we do rely on them, on their authority, on their brand to be able to sort out any issue that might arise. We are with the Swiss Legaltech Association today, so I thought that it will be beneficial to talk about a more legal example. Rocket Lawyer is a US-based platform that I'm sure that you are aware of. It allows do it yourself contracts, legal contracts online. So you can potentially feel, you know, like create a rental agreement online, and it's very convenient for a consumer. The truth being here that this is a clear example in which disintermediating the process could be helpful, because right now what happens is that Rocket Lawyer hires a few lawyers, and they ask them, you know, okay, please prepare me a repository for all these type of contracts. Then they take this work, that these brilliant lawyers do, and they host it on the platform. And Rocket Lawyer now is the company that earns money recurringly for each use of these contracts. So you know, the lawyer has worked once, but the money, it's being made recurringly by Rocket Lawyer. What instead, could we imagine instead another way of doing this, in which the lawyer directly is the one creating the contract, the template, and he is able to directly sell to the consumer with an online platform? Wouldn't that be interesting to see? Because the lawyer himself becomes his own business developer as well. These are the kind of you know, problems that embracing decentralization brings, but these are also opportunities. So that's what we see here. Today, most of the decentralized applications really lack user base. We are, as I said, in the infancy of this industry, so it will take time. In 1998, no one imagined to put a credit card on Amazon website to purchase a book. Today, that seems like a given, right? It seems like not even a book, but we buy any sort of thing from Amazon. During the COVID, people started buying groceries from Amazon. So that's, you know, it takes time to get at that stage. Today, if you open any DApp, and I suggest you to go to this website called DApp Radar, you will see that even the most famous platforms have very less users. So we are not talking about, we barely touch 100, maybe 1,000 in the best case. So 1,000 users for a decentralized application, whereas a normal platform like Facebook can easily do millions of users on a daily basis. So that's the kind of difference in scale. It's important to keep this in mind. One important thing, in fact, is that in Jure, you know, it's been a while that we are around, despite, you know, the difficulties that the crypto market and the blockchain market as a whole has been facing in the last years. But we are still there. We are really, I mean, we're really solid. And the reason beyond this is that we don't apply blockchain wherever it's possible. We apply blockchain where it's needed. Like when we see that there is a value, when we see that there is a scope, we factor that, and we analyze pros and cons, and then we understand, is this going to be beneficial for the client? Is this going to be beneficial for the user? That's the process that we do, and we call this leaned up model, which means basically that we don't assume. And we don't say, yeah, we should do a blockchain. It's mandatory to put blockchain everywhere. It's mandatory to put tokenomics everywhere. No, we think always of, is this going to be beneficial? And we validate. So we interview a lot of lawyers. We interview a lot of companies to understand what are their needs and where blockchain, yes, it's needed to increase transparency. For example, the appointment of a judge, of an arbitrator, if in an arbitration process, that's a process in which, okay, I need to trust that this process is transparent, it's not corrupted, but what if instead, you know, there is an auditable way in which both the counterparties can audit that process and make sure that it went exactly as it was supposed to be. That's the kind of thoughts that we are doing in Jure. So thank you, everyone, for joining us. I'm really, really glad that we had the chance of connecting with the Swiss community. We are a Swiss-based company. We are based out of Zug. So it's really good to be here and to your questions.
Okay, Luca. So thank you very much. I was just taking 1 minute to ask all our audience, what do they think about this webinar? And just don't please answer on chat. We have a link for it. There is this quality feedback form that it would be really amazing that all of you can answer to. And it really takes only 1 minute to be done. And it will really help us creating an even better, if possible, every time it's possible to create an even better webinar. So that would be very helpful, and thank you very much for that. So I see on stage a lot of people now, And let's start just by answering Tanvir Monim, Luca, because there is this question by him that it's calling on your speech. And after that, that would be really amazing if you guys can also have a last chat between each other. It's not that doesn't happen so often that we meet these days. So maybe Rolf will also want to add something at the end, and that's it. Thank you very much.
Thank you so much, Fede. So yeah, let me take this forward. Okay. Who would generate the leads for the lawyers if they want to directly sell to customers using DApp? Wonderful question. Decentralization means, you have generally you have this centralized authority, and we are the users and consumers of the services that these authorities provide us. And for example, if you think of marketplaces in which you buy and sell, so there are buyers and sellers, let's say eBay. If I am an eBay seller, I do need to do my own marketing activities to attract customers. But eBay helps me in that process because, for example, I can create a listing, like I can pay eBay a fee to highlight maybe the title of my listing and make it more visible to the users of the platform. So in that case, we are talking about the centralized platform, centralized solution. So the solution that we use every day, apart from the platform that does its role by trying to promote and attract users to you, clients to you. You also do a proactive. You have a proactive role to be able to be a better seller. In the same way, so it's a similar way. In a decentralized application, you become the business developer. Okay, so you are the one that actively and proactively try to sell, for example, legal services. Okay, let's assume legal services like a legal template that you drafted and you want to sell to companies. You should be the first one, trying to promote. For example, you can reach out to other communities. You can reach out to companies explicitly saying, I have this amazing template selling on this XYZ DApp. And that's part of the deal. But the beauty in a proper decentralized ecosystem, that's why it's called ecosystem, is that it's not only you alone that is doing this activity, but also the other actors of the ecosystem might be interested in bringing traffic to you, because if they see your template, they see their templates, and this brings everyone is interested in the success of this, because we are competing against you're competing against the centralized solution. So decentralization really means that everyone works together, because we really want the DApp to be successful, and we are all going into that direction. So I hope this answers the question. It's, of course, there is a greater level of detail, but this should make the point. It's basically what you have done before. You're doing that even more. So it's really on you, but others will co-help.
Thank you very much. And we also have another question. Maybe this question would be likely to be answered by Ale, our CEO. And the one by Naume, I hope the pronunciation is correct. Ale, can you start live answering this question?
Sure.
Sure. Okay. Thank you.
So hello, everyone. I hope that you will be able to, listen this answer. My connection is really bad. That's why I'm joining only now. So thanks, Bikirizi, for this question. She's asking essentially if, what does happen in case there is a decision outside blockchain. For example, there is a decision from a public court which says, which settled a possible dispute which was managed by a smart contract. She's asking how is going to be applied the enforcement in that case. So that is a really interesting question. Mainly, it depends on how the smart contract infrastructure has been developed. So eventually, if there is some kind of oracleized, so if there is an oracle, let's say a system according to which someone can give an input in the smart contract saying, look, there has been a decision on this topic, please act accordingly. In that case, eventually it's possible to, intervene, as you probably might want to know thanks to this question. Our point in jury is that, by the way, if you see the data, the current data regarding the dispute resolution in public courts, for example, they are quite, quite inefficient sometimes. They can take a lot of time and also high costs. So our point of view is that it doesn't really probably make totally sense to imagine that, in a near future or in a medium long-term future, there will be this kind of system according to which you have fast, reliable, and really, quick smart contracts on one hand, and at the same time you have procedures before public courts which can take 2, 3, 4 years. So we would like to think, and we are doing it also this at JUR, that for this kind of disputes, also blockchain-based dispute resolution system should be able to complete the efficiency of a smart contract, because at the end of the day, it's quite rare to imagine a system, smart contract based, which can be self-sufficient and that in any case can need an external input like a dispute resolution system. I hope that this answers your question, and I'm available for further questions also in the chat of JUR or in the next meeting of this session of webinar. Thank you so much.
Fede, I see so many questions. Maybe we can take some of them forward even afterwards. There are some ones that are really brilliant, but I have one question for our host, for Rolf, because being him really an expert in the field and following the industry from long, would like to ask you, Rolf, about how do you feel like the legal tech, especially industry, is shaping up in the next years, especially with the focus maybe on Switzerland? Like, how do you feel about it? Like, what do you feel it's upcoming?
Yeah, first of all, thanks everyone for your participation and your inputs and your speeches. It was very interesting, I think, for every one of us. To be concrete on your questions, I have quite a lot of discussions with colleagues here in Switzerland with lawyers, and they ask me, why are you pushing legal tech so much? Because at the end, it's kind of a cannibalization of our core business. So why are you doing that? And I think it's exactly the main question. I'm absolutely sure that possibilities, tools, solutions will come, is it on blockchain or not, which will disrupt as well the legal industry. And why shouldn't we do it by ourselves? So cannibalization of our main business, I think, of our legal service industry, with new solutions, closer to the needs of the customers, perhaps. Because if we do not do it, if we are not able to do it, someone else will do it. So data-driven companies will come and will do it. And if that fulfills the need of the customer, so the customers are at the other side and not on our side. So that's exactly what I'm absolutely sure. It's just a question of how many time will it need to enter in this next, let's say, valley. Not crypto valley, but in the next valley, to really go in new kind as well in the legal industry. And I think we make the right thing to think about now what happens in the market, what does it mean for us as a legal service provider, and how can we fulfill the needs of the future of our clients with regard to using technology to be more efficient and more effective. A second remark to finish, we have in Switzerland that big project with regard of being more efficient in the jurisdiction processes. So it's called e-justice, and I think it's called e-justice.ch. And that's exactly what is needed now to be more efficient as well in the legislation process. And if you go to court, that's the same thing. I think the court processes have to be more efficient because we have the problem. You have shown us that that a lot of people cannot go to court because it's too costly and it's too less efficient as well. It needs too much time. And so if we can improve these processes with the aid of technology, I think this is really from a social point and how to say, yeah, from a social point of view as well, a very important point. It opens the possibility for the people to enter in possibilities to find solution between parties. Could be on court, but it could be outside of the court process. And I think that's exactly where we are. It's just a question of time, but it will come, and I'm quite sure about that. The reason why it is so important what we are doing with the Swiss Legaltech Association to open the eyes for new possibilities with our colleagues and to see what happens in the market. That's exactly why we are the so-called think tank for legal tech in Switzerland to open this mindset, I think, as well.
Thanks for that, Rolf. Maybe Halle, you want to add something because Rolf has touched the point of course, inefficient course, and you are a very big, advocate for improving those processes with more efficiency.
Yeah. I mean, before that, I would like to answer to Rolf, because what he's saying about Swiss Legaltech Association, in my opinion, it's really important and valid. Yesterday, we were doing a webinar with the Swiss Private Equity Association, the SECA, and someone asked me, but how do you, why you are really pushing so much in the legal technology when, maybe sometimes the environment is a bit conservative, and how do you think to be able, blah, blah, blah. And with that regard, I think that associations like Swiss Legaltech Association are really important because, it's also thanks to this approach and this more modern and forward thinking, groups of people and professionals that technology can be adopted and eventually adopted in the right way, which creates value eventually for everyone, or reducing, let's say, the imbalances. About the justice, I totally agree, and we are going to release soon our product, which is an online arbitration, blockchain based, where it is needed, and it's an open justice, let's say, which means that some partners can open their digital arbitration chamber, and our goal is to increase the speed of the arbitration procedure and also reducing the costs. And we are doing that with several legal tech groups and associations. We will also talk more about that if you would like. So that's my answer, Luca, essentially.
Thanks for that. I appreciate it. Actually, when we were some time back, I don't remember actually which context, but someone asked us, okay, this whole legal tech shift is happening, like we are moving towards more technology in the legal industry, but what does it mean this for the lawyer? Like, he's the lawyer or the law firms, do they need to start becoming experts in any way? Like, do they start to code themselves? Does the lawyer need to start writing smart contracts and so on and so forth? Like, is it needed that the legal profession changes completely the way in which it's taught? Like right now, maybe you study certain subjects, and maybe someday you will be starting also learning about computer science, maybe some programming languages in the degree, in the normal law degree. So the question for the three of you is, do you think lawyers should start becoming more tech-oriented, as in first-hand, like they themselves start understanding the technology and start doing some fiddling around and so on and so forth, or three options actually. Second one, do they instead need to just understand the context? Like, okay, there is this technology and it has these pros and cons. Or thirdly, just remain as you are and outsource, find good partners that can do this for you. Like the technology, okay, it's on them. So maybe we'll start with Rolf, then Ale, Raffaele.
So to be short, yes, yes, no. I'm absolutely sure it will be important to make a big step in an interdisciplinary way. I'm quite sure if we want to be a solution provider for our clients as a lawyer, we absolutely need to have the focus more on context knowledge. A little provocative sentence to say, it's not enough just to be a lawyer to find solutions for our clients. I think the legal part is one aspect, but usually the world is getting and stepping in a new area where it's increasing, where hybrid solution, technology solution, which are combined with offline solutions are there. So it's to find solutions for our, especially corporate clients. It is absolutely needed to have more an interdisciplinary focus and to have more context knowledge. And I'm sure, or I think that if we think that we can work like now and stay in this, what we are doing, and hoping that we can perhaps outside something, or it will not come, perhaps it's like a thunderstorm which will go over. I'm absolutely sure it's not like that. So we have to be part of this development as well, and we have to think about how we can combine knowledge. And I'm sure that in our law firm as well, it's question of time where we have job profiles which are legal engineers, which have legal knowledge and has technology knowledge as well. Again, I think it's just a question of time, but I think it will be quite fast, the situation. But I'm very interested about Raffaele's point of view on this topic.
Go ahead, Raffaele.
Okay, yeah, sure. But, well, actually, I totally agree with Rolf. And in this sense, I am actually attending a computer science course for lawyers, because as I was mentioning during my presentation, I don't think that it is strictly necessary that a lawyer becomes also a coder, but it is necessary that a lawyer understands what coding is, understands how a developer thinks. Then, of course, the more you know, the better. That's true in any kind of situation. But if we think about what is necessary, the lawyer, if a lawyer wants to be able to use, to adopt, to understand technology and legal tech solutions, I personally believe that some kind of knowledge on computer science is required. And I would like to add something here with reference to legal tech. I have been also asked how and why I push for legal tech knowledge. The point is that, in my personal view, a lawyer's job is pure intellect. Then, for bureaucratic reasons, we also have to do something that is more practical, but it's not the core business of a lawyer. The core business of a lawyer is to apply his or her intellect to solve legal issues. If I have a software that automates something that is just manual, just practical, that would allow me to use more time of my day for applying my legal expertise to solve legal issues. So this is why I think that legal technology is important. Alessandro, to you.
I think that some problem with lines.
Okay.
No.
So anyway, this is my point of view. I know that not all lawyers do not agree with me, but I'm trying to push this way of thinking in all the webinars and events that I'm taking part.
I totally agree, Raffaele. That's for sure.
So Ali, if you want to give your answer to Luca's question, and this will be also the last intervention for today. So I also, for this minute, to say thank you everyone for coming. And I think that this event was a complete success. And it has been lovely to see you guys also talking each other about Legaltech. And I really think we should do a second version of this webinar, maybe, I don't know, sometime from now. Let's see. So Ale, please.
Well, I mean, I will be really short. I totally agree with Rolf. So it's, I mean, it's so important, I mean, to understand the new mindsets. And there are also a few examples to be done, like, you know, some lawyers sometimes have, or in the past, personal assistant to read the emails, print for them. They read, you know, the paper contract and sign. And this analogy is quite important for me, because at the end of the day, it's not only a waste of time and eventually money for the organization, but it's also a matter of, you know, reactivity on the job and to adapt yourself to something else. So I would say absolutely yes, it's important to understand the logics, but my personal view is that probably I mean, a lawyer doesn't have to become a web designer, a coder completely. Why? Because to go deep in that scenario might be difficult. So I think that the important thing in several, you know, verticals of human experiences is to try to understand the why, the meaning, and I mean, to go really deeper, it's quite complicated. I mean, I'm uniting myself in Fede, thanking all of you for being here with us for, I mean, the full 90 minutes together, and I'm looking forward to doing the next one. Thank you, really, Rolf, for letting this happen. We'll be really glad to come back on other topics with you with the same format or other ones. Thank you so much.
Thank you. Thank you, Fede, for moderating.
Bye, everyone.
Thank you, everyone.
Thank you, everyone.
Thank you.
It was a pleasure.
Bye-bye.
Bye.
Bye.